Okay, great. Thanks, Celine. So, hello, everyone. Thanks for having us today. My name is Dr. Daniel Alati, and along with my colleague here, Mr. Arlan Delisle, we're just going to speak today about some research that we've been doing as part of a multidisciplinary research team at MacEwan University. Arlan, did you want to go ahead and give yourself a quick introduction before I start off here?
Sure. Thanks, Daniel. So I'm Arlan Delisle. I'm a assistant professor at MacEwan University in the School of Business. I've been a practicing lawyer for about 20 years, and now my main gig is teaching at MacEwan, teaching business law courses in our undergrad programs. And as part of my research, I'm going to talk about that here as part of my presentation, and how I'm going to contribute, hopefully, to the success of the project that we're working on. And yeah.
Great, thanks, Arlan. So I'm just going to go ahead and share my screen here. Okay, everyone can see that?
Yeah, looks good.
All right, great. My connection's just a little, seems to be lagging here. I might just turn off the video if I can. Just bear with me for a moment. Okay, yeah, that's a little better. And you can all still hear me fine, yep. Okay, great. So like Arlan, I'm also an assistant professor at MacEwan University, which is in Edmonton, Alberta. I'm in the Department of Sociology. I teach on the criminology stream, and my research and educational background is kind of evenly split between the fields of law and criminal justice. I'm a comparative law and criminal justice scholar, so I work in these areas. I do research on Canadian criminal justice in the context of global developments as a comparative scholar. So I've previously done this type of research in fields including drug legalization and drug policy, as well as Canadian national security in global contexts. And this project looks to place Canada's use of restorative practices also in a comparative context. So I might start off today by telling you all a little bit about the project history and how the research team came together and the auspices of the grant that we received. So I'd like to thank MacEwan University for supporting this research through a strategic research grant. That grant allows researchers at MacEwan to put together multidisciplinary research teams that engage professors from different parts of the university, as well as different community organizations in research grants and research activities. So this project engages 3 professors, so myself, Mr. Delisle, as well as Dr. McKay White, who was going to be part of this presentation, but sends his regrets while he deals with a personal matter. I'll present his component of the research later on. But it's the 3 of us representing 2 departments at the university, as well as our community partner, which is the John Howard Society of Alberta. The grant provides funding for an 18-month project duration that contributes to a bunch of different research outputs, which I'll discuss in just a moment. One of the major Outputs to come from the research grant funding is a culminating event that'll be occurring at Grant MacEwan University in May. So at the end of my presentation today, I'll share the link for that. We'll be having an event related to this research work next May. As part of the joint initiative, all of the project members bring something different to the project. So myself in particular, I'm focused on the comparative angle, utilizing my previous expertise in this field. Dr. White, as well as Mr. Delisle, have quite an extensive background history as practicing lawyers. So they also bring some specific expertise in those fields. Mr. Delisle also has expertise working in areas related to Indigenous law, which is really a core focus of the component of his research, which I'll talk about later on today. In regards to the motivation for the study and why I decided to apply for this research grant and engage in this research work, I was finding that in this area, there was a real gap in literature, especially Canadian literature, in regards to restorative practices. So some of you may be familiar with restorative justice, which is the implementation of alternative type principles based less on adversarial means and more on repairing of harm, insofar that it's practiced in the criminal justice system. So the use of restorative type measures in the criminal justice system has been well researched, but in broader legal and quasi-legal contexts, it's been far less researched. So we saw a gap that was present in the current research that gave us an opportunity to contribute usefully. I think it's fair to say that all of us believe quite a bit in the cause of addressing access to justice issues in this country, and that really provided for a strong motivation for us to engage in this research. So as I mentioned, we all have different project outputs that are coming out of this research grant. Mine will be a book publication that will be published with Routledge next year in 2024 with a similar title to that of this presentation. So at the end of today, if you are interested in following that publication, I'll be happy to share more information with you about that. And I'm sure Dr. White and Mr. Delisle will also be happy to point to the research outputs that they'll be putting forth as a result of this project. Okay. For my component of the research, I utilize a methodology that I've used in my previous two book publications with Routledge, including my most recent publication, which was a book entitled Drug Legalization in Federalist Constitutional Democracies. This is a blended form of research methodology. It mixes traditional doctrinal legal research, so looking at legislation, case law, primary source materials, and quite a bit of historical analysis with a sociological blended qualitative interview component. So it involves speaking to folks that are engaged on the ground level with this type of alternative justice work. It also has a core comparative component, as have my previous works. So the practice of Canada in this regard is going to be placed up against a number of relevant overseas jurisdictions, namely places like Australia, New Zealand, the United Kingdom, select European states, Brazil, countries that have experience with the use of these restorative practices. Arlan, can you still hear me? Everyone awake? Right on. Okay, so by now you've heard me say restorative practices a number of times, and some of you might be wondering what are they? So restorative practices have deep roots with Indigenous communities. At their heart, restorative practices recognize that traditional adversarial forms of justice, which have been practiced in more formal settings, i.e. Courtrooms in the criminal justice system, aren't effectively addressing the root causes of conflict. They're focused more on repairing harm at the individual and community levels, providing for greater sense of ownership and for healing. And that definition comes from the International Institute for Restorative Practices. So in a nutshell, restorative justice measures are aimed at addressing what I would argue is a systemic failure in adversarial justice mechanisms. Most of our criminal justice system, as well as broader legal processes, things like civil litigation, family law, and other areas are very much based on an adversarial system of a win-lose type outcome, where the main process is to punish and assign blame rather than it is to try and repair harm or assign accountability. So this is where restorative practices try and step in. They're used in a wide variety of contexts. We use a pretty broad definition of how we contextualize this term. So restorative practices can be diversionary measures, they can be mediation, and they're used in a number of different legal contexts. Mandatory mediation is just one example that occurs in civil litigation in some parts of the country. They're very frequently used in family law cases where recent changes to the Divorce Act have called upon lawyers to actively and strongly suggest mediation for individuals that are involved in family law processes. They're also increasingly being used in non-legal contexts. Businesses are setting up forms of alternative dispute resolution, and in a lot of universities. So MacEwan University, for example, has a restorative practice academic integrity procedure. So when a student engages in an academic integrity violation, say cheating on an exam or plagiarizing a paper, there's the kind of traditional adversarial process that exists. So a student commits an infraction, an adjudicator listens to their case, looks at what is dictated in the policy and kind of levies a punishment or what you would call a sentence, I guess, in a criminal justice type context. Whereas we also have a parallel process that runs alongside that's entirely voluntary. So if you have voluntary participation from the student, the professor, and the people involved, a separate process is run where all those people come together and they speak about the incident, they speak about the harm that it caused, they speak about what it would take for genuine accountability and for harm to be repaired. And through this process, alternative measures can be used rather than just levying a punishment. Oftentimes, there's a collaborative discussion around what would improve the students going forward, and some more creative outcomes can be produced by this process. So long story short, there's a wide variety of legal and non-legal contexts where restorative practices are being used. And we argue that there's a need for more of these restorative practices to be utilized in a variety of legal contexts, including criminal justice, but also broader. It should come as no surprise to anyone that's been attending this conference for multiple days to hear that Canada has a genuine access to justice crisis. In Canada, legal costs combined with things like undue delay, court backlog, increased marginalization of certain minority groups and overrepresentation of minority groups have for some time meant that access to justice is a real issue in this country. So most of the criminological or legal research in this area points to different failings of the traditional adversarial method of justice. Points to some of the things that I've already mentioned, but also argues that the adversarial justice system, whilst primarily focused on meting out punishment and engaging in deterrence, does not provide satisfaction in a lot of cases for victims or for those impacted by crime. So we argue that the very real access to justice issues in this country and failures of adversarial modes of dispute resolution open the door for discussions of increased use of restorative practices to address these issues. Okay. So what is the main research problem or research questions that at least my book is looking at? First, the task is to fill in the gap on restorative practices as opposed to restorative justice. So as I've mentioned, restorative justice, insofar as it's practiced in the criminal justice system, does have a strong wealth of literature behind it. But restorative practices in other legal contexts like civil mediation, family law, child protection cases, etc., is far less developed and is in need of further research. So because of that, this book seeks to engage in a comprehensive accounting of restorative practices, initiatives, and programs that exist across the country. So it will be doing a comprehensive countrywide scan of the types of programs that currently exist. Similarly, the book will have a strong comparative component. There is at this time a lack of comparative studies into these types of measures that the book will hope to address through its comparative analyses. There's also few research studies that consider the issue of Indigenous justice and cultural appropriation. So there are a number of questions being asked in the book about whether or not certain restorative measures being used in the quote-unquote mainstream are a form of cultural appropriation from Indigenous justice principles and practices. There's also some questions being asked about whether or not restorative practices occur more or have greater chances of being successful in areas where some of these Indigenous traditions are present. Okay, so as I've just mentioned, by the time the research project has concluded, we're about halfway through now. We'll be able to provide, through my book publication, a comprehensive scan of restorative practices, initiatives, and programs that exist all across the country, and use these to address the lack of comparative research in the field. There'll be analysis that explains regional variety of these measures. So is it the case that Alberta has significantly more widespread use of restorative practices than, say, Ontario or other provinces? Why is that the case? Is it a systemic issue? Are these programs more well-funded in one area of the country? These are the types of things that will be analyzed and provided in the book. The comparable jurisdictions should provide for lessons learned or best practices in regards to how these mechanisms are used in other jurisdictions. And again, lastly, answers to some of the questions in regards to the issues related to Indigenous traditional practices that I just mentioned. Some very preliminary results so far. Again, the final publication of this research work is still about a year away, but some early results from some of the work that I've done towards this book. Restorative practices as they are currently used across the country are what I would best characterize as piecemeal. So what I mean by that is that they're not the result of some comprehensive strategy or policy coordination. Rather, they develop in a largely sporadic fashion in different jurisdictions, neighborhoods, communities all across the country. This is largely because a lot of these programs are funding dependent, and that funding can be quite transitory. So that's a pretty common problem that or at least I've found in some of the conversations I've had with people who work in this field, or in looking at some of the program architecture and websites. You have a program that receives some kind of grant funding. It runs for however many years under the auspices of that funding. It might have very successful results, but then the funding runs out and the program disappears. So there's really a lack of coordination at any kind of federal or upstairs type level in regards to these measures. Should also note that in many ways, restorative measures, including restorative justice measures, over the years have been very much viewed as a niche or an alternative or some kind of experiment. There really seems to be within the public consciousness a misunderstanding of the prevalence of a lot of these types of measures. As I've already kind of mentioned, something resembling restorative practices have been used in this country in a variety of different contexts, whether it be mandatory mediation in Ontario, in school contexts all across the country, in family law contexts, or in the criminal justice context for decades. So I think it's fair to argue at this stage that restorative practices are much more ingrained in mainstream legal processes than the average person perhaps knows about. So this goes to part of the issue with restorative practices and the argument that they need broader awareness. So in order for restorative practices to better be implemented at a more broader scale across the country with an eye towards providing for more fair justice and addressing access to justice issues, the utility and success of programs that have been operating needs to be better advertised. So that's really, part of what this book is trying to achieve, is to give some notoriety or shed some light on the fact that many of these programs have been working quite well across the country for some time. And lastly, a very preliminary scan of restorative practice initiatives does show that in jurisdictions where there are large Indigenous communities, these communities have led to greater prevalence of restorative initiatives and programs, Alberta being an excellent example. Alberta is one of the provinces across Canada that does implement more restorative practices than other provinces across the country, and particularly around areas where Indigenous communities have been working to use these programs and have them brought into the mainstream. Okay, so I'll finish up today just by putting out a call for collaboration if you work in this area or if you're interested in this field. As I said, as part of the Routledge book publication, I'll be talking to folks who work in the fields of access to justice, broadly construed. So don't hesitate to contact me. If you work in a field where you feel like our research could be usefully advertised or shared, again, don't hesitate to contact me. And I'll also just put up my email with our event link there. So this is the event that we'll be holding at MacEwan University, 7 May next year. We'll give you an update on the project work that the three of us are working on, and also have keynote speakers representing various different elements of civil society who work in these areas trying to address these access to justice issues. So that's it for me. I'm not sure if if you've been following a standard format with question period or anything like that, or if we should just share the floor with Arlan here to talk about his part of the research.
Okay, did you, let's see, I'm kind of keeping an eye on the chat as you were talking, but I didn't see any questions jump out at this point. So I'm probably okay to do my portion of things. Or we're going to talk at all about McKay's contribution, or we'll just kind of note that at the end?
Yeah, why don't we let you go?
Okay.
Just so I can have a bit of a talking break.
Yeah. Okay.
Yeah, and I'll
that's
contribution as well.
Okay. Well, and that's a good idea, because when we did a version of this in Calgary a couple weeks ago, you and McKay went on so long, I had to really compress my component. I really sensed a disappointment in the room that I wasn't able to more fulsomely canvass my my slides. No, I'm just kidding. But thank you very much for throwing it over, and thank you so much for spearheading this initiative here. and this project, and asking me to come along with it. I'm really grateful for the opportunity. So thanks again. Okay, I'm going to try to share my screen to hold that one up. There we go. Okay. And yeah, so I'm going to talk for a few minutes about the part of this project that, or I guess how the research that I'm doing is going to work into this. So as I said at the start, I'm an assistant professor with MacEwan, just going through my second full year being on full time. I taught sessionally a few times and decided to make it my full-time gig. Still am practicing. I do a little bit, like I'm still active with the Law Society and do a few things for a few clients, but this is my main role now. And as part of my professorial appointment, there's an expectation that I'm doing some research and some writing. And so I'm going to talk a little bit about my approach to that component. And as you can see from my first slide here, I've got the title. It's my sanitized internet-friendly version of the title, Substantive Responses to the Calls to Action. I figure that one's solid. You can take a screenshot of that and put it up. Delisle was talking about this. I'm not afraid of that. That's great. But I've got a bunch of working titles that I use when I'm thinking about my project and my research, and they vary from things like, why is everything so stupid all the time? Or sometimes I just kind of sigh. But I've got another working title that I come around to, but in order to get to that, I'll give you a little bit of where I'm coming from on this conversation. I grew up in rural Alberta. Right now, I'm just west of Edmonton, here in Treaty 6, west of Misquachie-Waskagan. I grew up in near towns called Fox Creek, Alberta, or Edson, Alberta. You know where Edson is. If you've ever driven from Edmonton to Jasper, you've been through Edson. It's that place you stop to fill up with gas and get a coffee. And so I realized that that's kind of a big part of what frames the way that I look at things, growing up in that kind of environment. And so when I'm talking about this stuff, I'm also cognizant, if you're in Alberta, a lot of people in Alberta are fairly recent, within the last 15 or 20 years, right? So I'm looking at kind of where I've come from, as well as how things have changed in the last in that time, and trying to find a way to talk about these things so that can be helpful to the larger conversation. Okay. But growing up in the 70s, 80s, 90s in rural Alberta, we didn't talk about Indigenous issues kind of with the same sort of tone that we do today. And I've been finding it interesting because growing up in that environment, there were still some linkages to traditional practices in some communities, or we weren't that far removed from them, and they were kind of there, but not really talked about. And so now that we've got an opportunity to talk about them and the calls to action from the Truth and Reconciliation Commission, I think help us with a framework to that. And so, but growing up, when I grew up and talking about these kinds of things, it was different then. And there's still some folks in my own circle that were struggling to find the right language to talk about some of these things, maybe in a less, with less racist overtones. Okay. And so often my working title for this stuff is not substantive calls to action, but conversations with my racist brother-in-law or high school friend. Okay, I don't want to pick on my brother-in-laws because I love them, been around them for 20 some years now. They're good folks, but sometimes some of the things they say I find challenging. But what I do know with these guys is if I can get them to understand why this stuff's important and to talk about it in a bit of a different way, if I can get them there, they're gonna come along with it. And so I'm trying to find ways that I can convince Leonard or you've got a Leonard in your circle, right? That from high school or wherever, if we can get through to them, then we're going to be making some progress, because once we get them there, then they're going to hold on to it. At least that's my hope. Okay, so that's part of where I'm coming from with this, or why how I'm approaching this. Okay, so the where I'm at in my research, or my starting point, is the Truth and Reconciliation Commission Call to Action number 92, which speaks to business and reconciliation. And I'll take a look at that here in a second, because I do teach in the School of Business. So I got to link into that, right? And I've been a practicing lawyer for, as I say, 20 some years, and or just about 20 years. And a lot of that time has been as in-house legal counsel, or as counsel to organizations, more on the procurement, the employment law, labor law, a lot of the practical day-to-day kind of advice. But I have also some background in prosecution work when I ran my own office, and some experience with the system in that context as well. But one thing that I talk to my students about in some of the business law classes is that from a business perspective, or corporate law perspective, a lot of what I'm actually doing is negotiating, or we're engaged in some sort of dispute resolution or risk management process that is being informed by what the common law might be, and the statute law. But we're trying to negotiate solutions before we're into that more formal legal debate part of what I'm doing as a corporate lawyer. And so the link into restorative practices is actually more clear than what it might be just at first glance. So as I say, my starting point here, though, is call to action number 92, which does raise the conversation about the UN Declaration on the Rights of Indigenous People, and look at a couple of I think others this week have looked at that, but that comes up in this conversation. And then as you see from the next two bullet points, I've got substantive versus performative as a question, or substantive and performative with a question mark after that. And I'm framing it like that right now because some of the readings that I'm going to touch on talk about that, and as I'll try to link together here, I think there's a role for both, but we have to be mindful of what we're seeing or doing when we are taking steps on the calls to action. Okay. Just check the chat for a second. I assume you're kind of keeping an eye on that too, Daniel. Okay. Okay, so call to action number 92. If you haven't heard of this one before, that's okay, because it's not one of the ones that gets the the same attention as some of the calls to action that are more government related. And so, and there's not been a lot of writing on this one yet, which also then is why I decided to kind of make this the focus of my own research, because I think there's an opportunity there to help inform the conversation about the calls to action. And I'm not going to read through each portion of it, but there is a lot going on here. The call to recognize or adopt the UN Declaration on the Rights of Indigenous People is prominent there as a reconciliation framework, and to apply its principles. That some of this isn't going to be folks attending this kind of a session. You're probably fairly well aware of things like the duty to consult and the idea of free, prior, and informed consent. So when I do a version of this talk to others who are, say, not as engaged with this topic, I go on about that a little bit, but I'm going to presume that that this is an audience that is already familiar with a lot of what's in the UN Declaration there. What I wanted to bring to folks' attention in particular for today, though, is in item 3 of call to action, or subsection 3, where it's calling on businesses to educate folks on the history, and of course, as we do in October in particular, the history of residential schools, UNDRIP, Aboriginal rights, Indigenous law, and Aboriginal Crown relations. The one that I'm really interested in right now, and we'll talk about a couple of resources that I've come across, is Indigenous law, because it's not in the same category as, say, Aboriginal law or even laws or Indian Act related law, right? What we're talking about here is actual Indigenous law, like the Indigenous legal systems that would have pre-existed colonization and continued, notwithstanding everything that's gone on, and depending on who you're reading, are resurgent, right? As part of the larger conversation that's going on, there is space, and there are people who are writing about this, right? The resurgence of Indigenous law, and so this is great for us on this project, as an example, because there's going to be more resource for us to draw from, and connections that we can make here. But I focus on that to just make the point, right? It means recognizing that that there are sources of law that we can be considering, and in particular in relation to resource extraction and whatnot. We need to find these sources and do a better job of being aware of them. And so that's part of what I'm going to try to do with my overall research. Okay. Okay, a couple of sort of non-academic resources, but resources that I've come across that are informing how I'm approaching this are Judy Wilson-Raybould's book, True Reconciliation, and Chief Robert Joseph Namwit, Pathway to Reconciliation. And so when I talk about substantive and performative, those are drawn from, as example, these two resources. And in particular, the Chief Joseph book I found to be quite helpful, because another point by way of background, when the Truth and Reconciliation Commission reports came out, I spent the summer after that basically my extracurricular activity was reading through those volumes, and that was a hard summer, right? And as many of you probably experienced too, if you're working in these areas, it can be taxing, right, and challenging. And what I was really grateful for to have come across the Chief Joseph book was it does leave me with some hope and more inspiration to try to contribute to the conversation and work through these issues. But it left me much more hopeful. Okay, so I'm just mentioning that because for those of us that do work in the system or involved with these issues, recognizing it can be overwhelming. That's something that's probably come up in other conversations, maybe even this week. And so just to be mindful of that. So those are two, though, that I came across that I point out to folks if they're in particular haven't been engaged on reading up on the issues. These ones are good ones, okay? At least I found. Okay. Another fairly recent publication that is helpful, again, if anybody's who's involved in on the legal side of these issues, John Burroughs is well known, and this Laws Indigenous Ethics book, I really like the approach of it, and I think even if you're not a non-lawyer person, it's a good resource because part of what we're seeing here too, I find helpful to read through these and to see how the material is presented and to get a better idea about, okay, the stories that get told along the way here are an important part of it. And that is going to be helpful in terms of trying to understand like the worldview, okay? And the other thing I liked about this one and this excerpt that I included here is, when you take a look at these concepts, some of them maybe don't necessarily land in our existing legal system perfectly, like love. What the hell does love got to do with our legal system, right? But he talks about it in a way that that does help to see that, or I found, helps to see there is a place for that there. But things like truth and humility and wisdom and honesty and respect are things that we can find at least are aspirationally included in our existing systems, and we can try to find the language maybe to link these things through. Now, the caution that I say when I talk about this kind of stuff is to make sure we're not just taking one Indigenous group's view or one author's statement about a particular Indigenous communities' laws and slapping it down onto everybody. Okay, part of what we're going to have to do here is in our different communities, different regions, be aware of what Indigenous law we're getting at, and we're trying to understand and to incorporate, because there might be common themes, but it would be, I think, we've got to just be careful not to slap down some grand unified theory of everything. Oh, here's your Indigenous law component, because it's going to involve understanding what are the differences between our different communities, and it might be different, say, from southern Alberta to northern Alberta, and there may be some overlap, but there may be some really important differences, and part of what we have to work towards is being respectful of what those differences might be. But again, I'm hoping that there are some common themes that we can look at and articulate in a way so that more folks can develop a positive view of this stuff. Okay, another example, Sylvia McAdams' Nationhood Interrupted, Revitalizing Niuwa Legal Systems. This is, again, one of the ones that that I found to be hopeful and is an interesting one to read, again, just in the way that the book is written and the way that Cree laws are taught and passed down, and so it's a resource to look at, and again leaves me hopeful because it is ultimately saying that there is a future for this, and it hasn't all been lost, and we can better understand how this kind of understanding of law and nationhood here, as is being talked about, would have informed the views of the parties at the time of treaty. And treaty is one that the treaty making process is one area that I'm thinking about a lot these days, and what the worldview would have been at the time, because I think that is another area that we need to do a better job of explaining and understanding, because there could have been choices made subsequent to treaty that would have informed our legal systems and the practices that ultimately were implemented, and maybe there's some things we can grab from that and have the basis for it. Okay. I'm going to jump over a couple of things here because we're going to run out of time. On the business and reconciliation issue, there are more resources that are starting to appear. A couple of good ones that I've come across is this Upholding Indigenous Economic Relationships, Niuwa Narratives. This is Professor Jobin out of the, if I'm pronouncing that wrong, I apologize, out of the U of A, talking about Cree economic relationships. And so this is a really timely addition to the conversation. And another one that I cite here is this Indigenomics, taking a seat at the economic table. What I like about the first one is its conversation, discussion about the rules and practices around economic relationships, and talks about this colonial dissonance, this disconnect that folks, participating in the current economic system that we find ourselves faced with, when it doesn't seem to allow for the balance that culturally, traditionally, would have been fundamental to the choices, right? And the Indigenomics book, I think, is interesting, talking about why it's good to have communities participating and individuals participating in the economic system. If there's a criticism of it, it's from some is going to be that it's really just accepting the existing neoliberal, whatever legal economic system, without maybe having a more fulsome conversation about what should change underneath that, or as part of that in our areas. Okay, and I mentioned these. As I say, my job in the School of Business is to teach business law courses. If you got a kid or somebody in my classes, don't worry, I'm still giving them a 100% fulsome and adequate education on the way things are, because we still got to work in this system, and so what I'm looking at here are some elements that we can be talking about as having maybe been could have been given more of an emphasis over time, but we still need to talk about the way the system works currently. Okay, just going to jump ahead with the in-drip action plans. Again, for an audience like this, I assume you're probably aware of this to a certain extent. I'm not going to go on about it here, but I will be coming back around to this, I think, in some of the research where we particularly talking about where we might be saying things, we're going to do things a certain way, but we're not doing a very good job of actually following up on it. At least here we've got some conversations going on about actions, and then whether or not they're substantive or performative, we'll have to come back around to. Okay. Another thing that I'm following that I just wanted to bring up is this work that's going on through the Métis Nation of Alberta has entered into self-government recognition agreement with Canada, and that has led to the MNA to start to reconstitute itself. Instead of being incorporated as a society under the Societies Act, it is becoming the Otipemisiwak Métis government, and has adopted a constitution and has started passing some more formal bylaws or laws that will be implemented. And so I'm following this because I'm a citizen of the Métis Nation of Alberta, so I've got an interest in it like that. But it's also, I think, got some opportunity to help with the restorative practice conversation project that we're looking at here, and seeing how this plays out, because it's an example of where the Métis Nation in this instance is creating things like its judicial branch, and going to have a judicial tribunal with members to make decisions over certain jurisdictions that the Otipemisiwak Métis government will have programs and services, and so I'm interested in seeing how this plays out. I haven't been involved in any of the background work for this. If you have been, or know someone who has, or you've got an interest in it, then please feel free to reach out to me, because I'm interested in seeing how this plays out. But again, it's also got the opportunity then to inform, going right back to that call to action number 92 about Indigenous laws. How does this judicial branch's decision making differ, or what factors are going to be paramount within their decision making, and what can we learn from this? Okay, so I wanted to just note that, and then there is sorry to kind of conclude my comments here. I haven't really come to any firm conclusions yet on things, on whether or not and what should be considered substantive and what should be considered performative. In other versions of this talk, I do get into those a little bit more, and in what we prepare for this project, I'm going to weigh in on those aspects of it, and we'll see how that gets included. One resource that I did want to bring to folks' attention, again, if you're interested in this, is this website called Indigenous Watchdog, and see what happens if I just click on that. We'll see if it brings it up on which screen here. But it does a nice little summary of, let's see if you put, where did it go here? Yeah, of where we're at on the different calls to action, and if you do anything like involving risk management, you're probably aware of the different kind of heat map or the matrices that you can apply to things, and they're taking that kind of approach here to give us an idea about whether there's been progress on the call to action that's in progress, not started, or stalled. And if I go back up here and I go to call to action number 92, in their view, from having reviewed what they've been able to access about steps being taken on call to action number 92, they're listing this one as stalled. And I'd be inclined to agree. But hopefully by being made aware of it, you'll know now that there are some of us who are thinking about this, and if you do have anything that you think might be helpful in terms of me and my journey on this topic, I'm willing to hear from you and would look forward to the conversation. Okay. So Daniel, I think that's probably where I'll stop then, because we're just about at our time. And in case there are any questions, I've still got a few minutes, but I guess I'll throw it back over to you. I got 3 minutes to talk about what McKay would have talked about in half an hour, but
yeah, I do see there's a question in the chat, and since we're going to run out of time shortly, I'll probably just note for folks that our third project partner, Dr. White, is particularly interested in access to justice for victims of economic abuse. So that would have been the topic of his paper today, generally arguing that restorative justice can and should be used for that form of intimate partner violence. So if anyone who's here or who watches this session at a later time is working in that area or has interest in that area, I would encourage looking up Dr. White and contacting him. I see that there's a question specifically for you, Arlan, if you wanted to.
It's the question about how have we partnered with Indigenous communities.
Well, one just came through from Guion, I think.
Oh, okay, about the publication. You know, I am still thinking about that. In contrasting myself with Daniel and McKay, I'm kind of a toddler prof. They're more mature in their academic progress. They know, as Daniel said, he's already had some things published. I'm looking at well, a combination of things. Perhaps like things like the Alberta Law Review, but that's a pretty specialized avenue that only lawyers or legalistic type people read. And so I'm thinking about what our options might be. And you know, part of it might show up in this project. And then otherwise, I'm still trying to figure out what the best way for me to get my stuff out there is going to be. So I don't have a good answer to that right now, but I will take any suggestions that folks might have. Just I wanted to go back up for a second to the question there was, how's the research team partnered with Indigenous communities? We're still, well, we hadn't communicated with community specifically about partnering on this one. The starting point for this project, and Daniel, you're probably better to speak about it. We did want to have a community partner for the purposes of the grant, but I think part of what we're doing by appearing at something like this too is to make folks aware that the event that is going to be happening in July. That when our event is
in May, yeah.
May. Sorry, you know, there may be opportunity. There's maybe opportunity for somebody to participate in that, and we can hope to have those conversations over the next few months here. And also part of why we're doing these kinds of presentations is to then make people aware. And if you are aware of communities that would be interested in participating in this, then to let us know. Okay. So I guess that's just a quick answer there.
Yeah, definitely through the event. The link that was shared allows for proposals to be shared for workshops. So we're hoping that we have different community groups that do work in this area put forward proposals for those workshops. We've advertised it previously, as Arlan mentioned. We were at the Alberta Restorative Justice Association conference towards the end of November, which has a pretty large contingent of Indigenous community members doing work in this field. So we're hoping that they'll participate in that event as well, and also reach out for collaboration. But yeah, the short answer to that question, Celine, is as Mr. Delisle mentioned, this is really just a startup grant. It's a short duration. So the hope is that this is kind of the preliminary seed for larger, longer research projects where we can more actively and more substantively partner with members of those communities towards bringing forward the research and having them involved in a more formal and fulsome role.